Okay, here we go. So we're going to look at the very basics of Maine victim rights law today. For those of you who've been in the business for a long time, a lot of this will be familiar. So don't hesitate to jump in with your thoughts around best practices and sort of how to implement all of this stuff and make it actually work. So I pulled up this statute because I think this is a sort of lesser known, but it's really important. The idea that every county is encouraged to have a victim witness support program. That is the responsibility of the district attorney.
Okay. So
And
I
that
actually, Amanda.
folks are encouraged to hire and train and provide support staff to the qualified people who are carrying out that victim witness support program. I just like to put this up there because I think that victim witness advocates, trial assistants, for those of you who might have that title, feel sort of the full weight of responsibility for carrying out victim rights obligations. But the way the legislature intended it, it starts with the counties investing the money and hiring people to carry this out. The responsibility rests with the district attorney. We're going to look at that a little bit more. And so I hope that you come to this training not with a sense of anxiety, like, oh no, like what am I not doing? But just with an open, curious mind of like, okay, like I've been doing this job for a while and I have a sense of what the law is. I'm eager to learn more so that we can continue to do more and carry out the law, but also do our very best to support victims and survivors. Okay, along those lines, I asked this question recently in a training for prosecutors. I did a CLE for them. And the question is, how many times are VWAs mentioned in the victim rights statutes? And I wonder if anyone has an answer or wants to chime in. Because I clicked too soon. All of the statutes say the attorney for the state shall. And I think that's another thing that's just important for VWAs to keep in mind. You've been hired to carry out many, if not all, of these obligations, but fundamentally, it really is the DA or the Attorney General's obligation. And so we want to think about all of this as a partnership. And again, if you're feeling like your county or your district or your office is falling flat in some way, don't carry that full weight, because it's a partnership, and the obligation and the buck ultimately does stop with the chief executive for your district or your office. So when we're thinking about victim rights, one thing that is really important to consider first off is who is a victim under the law. If we're going to sort of consider the law as the floor and the baseline for the very basics of what we provide. Now, just because there's that floor doesn't mean that we can't serve other people potentially who may be affected by the crime, and that could have benefits. But if we're just looking at the floor, just doing the bare minimum, who is a victim? So for most of our victim rights statutes, so in particular, the one that applies to confidentiality and the one that addresses the basic notification rights in Title 17A, a victim is going to be both the person against whom a crime is committed. Now, the statute uses that word person, which is interesting. You know, query whether Walmart is a person, although Walmart is the harmed party in tons of the crimes that I know that you all end up working on. And so, but let's keep that in mind if we're thinking about notification provisions, if we're thinking about confidentiality. There's an argument there that maybe the statute only applies to human people. And victim also includes the immediate family of that person if we're talking about domestic violence, sexual assault, or a family member who has a serious physical trauma or serious financial loss, or in the situation where the victim can't participate because they're dead, because of their age, so they're a minor victim, or if they have a physical or an intellectual disability that would impede their ability to fully participate in the process. So that is one definition of victim that shows up in the victim rights statutes. Now, there are other victim definitions as well. So there's a different definition that applies to restitution. Restitution can also be owed to a government. So the government could be considered a victim in a restitution case. And there's also a different definition that applies if we're looking at victimization or victims compensation and thinking about the eligibility criteria there. We'll look at that briefly when we get towards the end. So Maine's fundamental victim rights, we can put them into sort of 6 general categories: the right to confidentiality, the right to information, the right to notification, the right to participate, the right to victims compensation, and the right to restitution. Those are our big, broad categories, if we were going to sum it up really briefly. So we're going to look first at the right to confidentiality. And my question for all of you, if you can chime in, you can chat, you can unmute yourself, because I think this is a really important question to ask ourselves before we dive into each of these big categories. Why does privacy and confidentiality matter for victims? Why do we aspire to try to keep as much privacy, as much confidentiality for them as we can, knowing that there are some limitations in the law? Does anyone want to chime in?
I mean, so one part for confidentiality, it can be a safety concern. So if you have someone, a lot of cases in domestic violence, we work with Safe Voices down here, they'll go live in the safe house. So me knowing that they're, in a confidential location is not something we reveal to defense or to the defendant, because a lot of times they just survived something extremely traumatic, and that little blanket of knowing the address and not revealing it is huge to a lot of people.
Right. Yeah. So I'm hearing 2 things in what you're saying. There's the literal physical safety, that it can be an actual threat to the victim's safety if the defendant knows the victim's location, for example. And the other thing I'm hearing in what you're saying is there's a piece of trauma recovery in there too. The victim knowing that the defendant doesn't know where they are helps them to feel a sense of safety, whether that's actual or not. We can never guarantee safety 100%. We should never put that burden on ourselves. But that feeling of safety helps them to get to a space where they can work on that path to recovery too. Anyone else want to chime in? Rachel?
Integrity of the case, as well as integrity of the office.
Yeah. So, right, like to have a sense of, and to build trust, right? Trust is a huge part of an effective relationship with victims. It is everything. And even though, again, there are things, and we'll talk about it, that you can't keep confidential, it doesn't mean that we can't lay that out in advance and make it really clear to victims what the bounds of confidentiality are, so that we can work on establishing a trusting relationship. Because when we start small and building trust, we're helping to create the conditions where that person feels comfortable contacting the office. They feel comfortable talking to the prosecutor when it's time to talk to the prosecutor about the case. They feel comfortable preparing for trial, and maybe we even get to a place where we're hoping for them to testify, and they trust us and trust the office enough to say, you know what, this is scary, this is intimidating, I don't want to do this, but I trust what you say about how this might go, and so I'll take that leap with you. So lots of reasons why privacy and confidentiality matter. So the other word that gets thrown around with confidentiality is this word privilege. And privilege is in our world is a legal term of art that gets at the idea of information that doesn't have to be disclosed in discovery, right? So discovery is that process where mostly it's your office, the prosecutor's office, sharing information with the defendant. So that's discovery. So if something is privileged, it can be protected from discovery, and or it can be protected from being admitted in the court proceeding. So depending on the rule of evidence that we're talking about, depending on the statute, that word privilege might apply to sort of either aspect. So when we're thinking about privilege and confidentiality, we want to be thinking about what type of information is protected, from what type of disclosure. Again, are we talking about discovery? Are we talking about admissibility? You know, who are we allowed to not give it to? And then are there any special conditions that would need to be met? And then next, are there some exceptions that apply? So in this area, privilege and confidentiality in particular, there's lots of exceptions that do end up applying, and we'll talk about those as well. Before I move on, are there any questions about sort of these big concepts? And I'll do my best to answer them. Okay, moving on. So when we're thinking about the right to confidentiality in general, there's a bunch of statutes. There's one that deals with the address and current location. So Courtney was sort of alluding to that type of protection. There's a statute that applies to communications to advocates. And there's one statute for community-based sexual assault advocates, so people who work in a sexual violence support center in your local community. There's one that applies to community-based domestic violence advocates, so the domestic violence resource centers. And then there's one that applies to our victim witness advocates and coordinators. There's also a statute that in some ways, I don't think bears a lot of our attention. We shouldn't give it a ton of our attention today because I think most prosecutors' offices do a really good job of this, but it protects the identities of minor victims of sexual offenses. We will look at that briefly though. So address and location. Here's the general rule that records that include a victim's current address or their location, or if it's a record that has information from which a victim's address or location could be determined, so living with mom, must be kept confidential. That's the general rule. That's our starting place. That's the presumption. But now let's look at what the exceptions are. So the address or location can be disclosed to another state agency. And the statutory language is more complicated, but generally we can say another state agency if it's necessary. So that could potentially be the Victims' Compensation Program, for example. That's a state agency, or the Department of Corrections potentially. It can be disclosed to a criminal justice agency if necessary. So that might be prosecutor's office, might be law enforcement. It can be disclosed to a community-based advocacy organization. So we're talking about our domestic violence and sexual assault resource centers. And the statute says if there's a written agreement, which is like saying an MOU, right? It's a memorandum of understanding. I think that's what that would look like. Good question to ask in your office. We have an MOU with Partners for Peace, let's say, if you're in Penobscot County. What does that look like? Should we revisit it and think about how we're going to share or agree to share information? And this is huge, the address or location can be disclosed to really anyone else if the victim either makes a request or gives permission. So the victim really holds this piece. It's up to them. They can make that decision as well. the domestic violence intervention program, or certified batterer intervention program, they're making a transition with that acronym. So address and location can be disclosed there, or the domestic violence center that is serving the same county where the defendant is doing DVIP or CVIP. So those are the big exceptions. And then there's also this issue of bail conditions. So the address or location can be included as part of a bail condition or any other court order. First, if the defendant already knows, right? So we don't have to worry about any of this as much, really, if the defendant already knows the current address or location. Now, I wouldn't say that we're going to broadcast this information. We're not going to share it. We're not going to talk to our, hairstylist about it, because again, we want to preserve the integrity of the office. The information is still protected. But we don't have to be worried about the address or current location going in, a form to the court as part of a bail condition if the defendant already knows. Or the other option is that the victim has requested that the address or location be included as part of the bail condition. The victim says, I don't want the defendant within however many feet of the house where I'm staying, and this is the address of that house, and we need that address to be included. So those are the options for possible disclosures if we're talking about bail conditions. There's also this option in discovery where, and I think that this provision may be underutilized. So the state can withhold the victim's current address or location from the defendant if there's a good faith belief that the disclosure might compromise victim safety. I would add too, for your, if you're talking to your prosecutor on the case, there's actually a Maine rule of evidence that provides even more protection and complements this part of the statute. So this is one of those moments in terms of best practice. If we identify a victim safety concern in the case, then it's worth flagging that and really thinking about whether the victim's address and location need to be included in any of the discovery. Okay. Any questions before I move on? So the next set of sort of information that's protected are communications to VWAs. We're going to break the statute down, but here's sort of the language. So the victim can refuse to disclose and can deny permission to a VWA to disclose confidential, written or oral communications between the victim and the VWA, as well as written records, notes, memoranda, or reports concerning the victim. So that's our general rule. That's where we're going to get started. This part B, which we'll talk more about, is really getting to what the VWA and the VWA employer's rights are. So here we go. We're going to break it down. What is protected? Confidential, written or oral communications between the victim and the VWA. I emphasize that word confidential because I think if the victim has broadcast something all over social media, then we probably don't need to be as concerned about whether we're going to protect that information. So let's say the victim, let's say part of what might want to protect is the victim told us that they are seeking counseling. And so normally that would be the sort of thing that we really want to look to protect if we can, because and they've communicated it directly to us, and the general rules, they communicated that to us. The general rule is that we're going to protect it. There may be an exception, but the general rule is we want to protect that information. Now, if the victim has spread all over social media, we happen to be aware of it, that they're going to counseling, they're really proud of it, then technically under the statute, that information probably isn't protected. Now, again, best practice. Do we want to talk to our hairstylist about it? Do we want to, broadcast that information? Do we want to even just spread it around the office to other people who are unrelated to the case and don't have a reason to be connected to the case? Probably not. We really want to preserve that sense of trust and integrity. But we can be less concerned with sort of whether the defendant is going to find that out. The statute is going to protect any written records, notes, memoranda, or reports concerning the victim. And so that might be both the notes that you take down, or perhaps an attorney takes down in the office about the victim when they've called, whatever it might be. But it also might be, and again, this is the general rule, but reports that have come in. There may be exceptions that apply, but there might be a victim's school records that you have for some reason. There might be the victim's compensation application that you have. Those would be other reports that you have. Now, what's the disclosure that we're going to protect? So the VWA or your employer is required to not actually disclose this information to the court, any other agency or person. And this could include a request for oral or written testimony about the communication, or the production of those documents, those written notes and records and whatnot. In other words, this is the scenario where you get a subpoena, right? Now, the sort of special condition that's popped in here too, and again, we want to remember this, victim's in the driver's seat. The victim can refuse to disclose and may deny permission. That's how the statute starts. That's the presumption that this right to keeping these communications, these records and notes protected is a right that is held by the victim. So they can refuse to disclose and can deny permission to disclose. Here are the exceptions, and there are many, and we will be familiar with most of them. So it makes sense that communications with victims can be disclosed to other prosecutors, right? Maybe this information needs to be communicated to the Attorney General's office because the case is moving to the Attorney General's office for whatever reason. As part of a mandated report, we're not going to go into mandated reporter things here, but some of you may have mandated reporter obligations. And if you heard that a child was being abused, you may have an obligation under the statute to make a mandated report. And so those communications are not protected. If the court decides that it's necessary to the proper administration of justice, that's like the legal words that are used after having a chance to review the documents or the contents of the communication, what's called in camera. So that's just the judge looking at it in chambers. The defendant doesn't necessarily have an opportunity to review it. This provision is anticipating the scenario where either the defendant has filed a motion to compel some sort of discovery, or maybe they've served a subpoena and your office has moved to quash that subpoena and now it's going to be litigated. It might be a situation where the office proactively files a motion to protect certain documents or information. And so again, the court may need to review the documents to make that decision, but would ultimately be protecting them in the meantime. The other scenario is where we might disclose communications that you've had with victims is if there was an investigation into the victim's cause of death, or also what's included in the statute is the cause of their incapacitation. So they're in a coma in the hospital, something like that. And then the final exception, and the one that everyone will be the most familiar with, because this is the most common one, is where those communications, records, or documents constitute exculpatory evidence. So that's information that tends to show that the defendant isn't guilty, that they're innocent of the crime. It doesn't have to be the smoking gun that proves it, but maybe it's something that combined with other things tends to show the defendant isn't guilty. Often where this comes up, exculpatory evidence is ends up being things that the victim has said or done or records that might suggest that they're not a credible witness. And therefore that whatever they've said isn't credible and the defendant is innocent. That's where we tend to see this most often. So before we go to the fact pattern, this on exculpatory evidence, what I want to say about that is it is a legal decision for your prosecutor to make, for your district attorney to make. Different offices have different policies around exculpatory evidence and sort of how much they want to routinely disclose to defendants. That's a judgment call that's not for me to make. It's not for you to make if you're a VWA or a trial assistant, because what's in jeopardy here is the possibility that a conviction could be overthrown, case dismissed, because the defendant didn't have the information that they were entitled to. And it's a matter of the US Constitution and the state constitution that they're entitled to this information. So that's the sort of dance that we're playing here. On the one hand, we do want to try to protect as much confidential information as we can to build trust with victims, to protect their safety, to protect the integrity of the office. But at the same time, prosecutors have these tough decisions to make around disclosures to make sure that they have met their discovery obligations and ultimately this conviction is going to stick. Any questions on all of these things before I move on? Okay, so I've got a fact pattern. So we'll assume that this is maybe it's a domestic violence case. It could be a stalking case. And the defendant and the victim are married, and the defendant's divorce attorney has subpoenaed you to appear at a deposition for a child custody case that involves the victim and the defendant. The victim has told you that she's concerned that she might relapse. She has a substance use problem, and she's concerned she might relapse while the criminal case is pending. And she's even considered giving up her rights and responsibilities, so her custody rights for little Jimmy, the shared son. This information is very relevant to the child custody case. What can your office do? What are the steps that you might take to address this issue? And anyone can share in the chat or unmute if you want. And maybe you have faced a similar situation before. I'm going to chime in because we have a quiet group today. When you're served a subpoena, first thing to know is that if you don't know this, but you should, because you are all responsible for filling out subpoenas yourselves and serving them, they have tight time limits. So we want to definitely make sure that we act on this quickly, although we don't need to panic, because just because you get served a subpoena does not mean that you're going to be required to testify. And in fact, in a lot of cases where VWAs get subpoenaed, they are not required to testify, and we can make this go away. So right off the bat, we want to make sure that we have the prosecutor on the case involved. Potentially, depending on your office, it might be really important to have your district attorney involved as well. Offices of different sizes have sort of different ways of organizing themselves for thinking about how to handle these things. One thing that we can do right off the bat is touch base with the victim. Now, I doubt it, but maybe the victim is okay with you appearing at this deposition or providing whatever information you have. And we saw in the statute right up front that the victim's right is to refuse to disclose or to give permission to you to disclose. And the victim's holding that right. So let's give them the opportunity. Do you want to exercise your right here? We'll protect this, but we're asking you whether you want to disclose this, or at least at the very least, we're going to do our best to protect it. We don't want there to be unmet expectations. That does a couple things too. It's possible that the victim will want to get their own counsel involved, and so this is helpful information for them in this case. And again, it helps to build trust. It helps to prepare them in the possibility, especially if we were dealing with a different fact pattern. It helps prepare them for the possibility that this information might be disclosed, even though they weren't counting on it. And then our next step is going to be to encourage the attorney on the case to pick up the phone, call the attorney for the defendant, and explain the statute to them. Because it's quite likely that this subpoena doesn't have a legal basis, and that because of this victim witness advocate privilege, if the attorney for the defendant decided to move forward, that your office would be successful in a motion to quash. Does that make sense to folks? Do people have questions about this fact pattern and how it might play out? So, if we walk through the exceptions here, the defendant's attorney is not another state agency. This isn't a mandated reporter situation. So she says she might relapse. That's not a mandated reporter issue. She said she's thinking about giving up her rights and responsibilities, but that's also not a mandated reporter issue. Although, again, that's a different training for a different day. We're not talking about a death investigation. We're not yet at a situation where someone has filed a motion and maybe the court can make a decision about whether it's necessary in the interest of justice. And we also aren't in a situation where this is exculpatory evidence, because it's a child custody proceeding in family court. So if this information about the possibility of relapsing, the possibility of giving up her rights and responsibilities for little Jimmy, if the prosecutor doesn't consider this information to be exculpatory in the prosecution of the criminal case involving this defendant, then the defendant's not entitled to it in the child custody case either. So that's how that plays out. Any other questions or comments before I keep moving? Okay. So the next set of rights that we're going to look at are the right to information and notification. And I'm going to ask a similar question that I've asked before. Why does information and notification matter to victims? Why do we bother to do this? Why is it in the statute? Because this is a huge part of the victim witness advocate or trial assistant role. It's a big part of what the Department of Corrections Victim Services Unit does. Why do we bother to do it? Trust. Joanna says trust. Anything else from folks? There's a safety piece. So if we're talking about getting notified about early release from custody, then getting notification in advance is an opportunity to safety plan. Any other thoughts about why we bother to do it? Got something in the chat, let me see. Yeah, so they know what's going on and they can be an effective witness and be involved in the process, right? And being involved in the process from like a brain science perspective, and we'll talk about this in trauma-informed communication, it can be a huge part of someone's trauma recovery. Knowing what to expect, knowing what's going to come next, having some sense of what those options are, what could happen, helps victims to regain a sense of control. So that's really important. And Joanna says, when dealing with our homicide cases, it's always better to have the family involved, and letting them know is huge, right? They want to know. And it's their lives. This happened to them, is what Courtney says. They deserve to know what's going on. Right. So, back when victim rights were first legislated around, throughout the country, it all started with information and notification. It just, in some ways, makes common sense. So this will be familiar to you, but we're going to walk through it. Victims are entitled to know the details of a plea agreement, including if it's going to be deferred disposition, before it's submitted to the court. Now, caveat on that, and I've talked to prosecutors about this, I know with some of these, it's not always possible for you to notify victims before it's submitted to the court, because you don't even know before it's submitted to the court. Sometimes prosecutors have pressure to move really quickly on cases, and they don't even necessarily have the time to make sure that to make sure that the information goes to victims before it's submitted to the court. Especially, we're recording this now during sort of the COVID court bubble. There's a lot of pressure to move cases. So again, to those of you who saw this and you got like a little bit of anxiety because you can think of those cases where you didn't get the information to the victim before it was submitted to the court, let's take a deep breath and relax, because there's a lot of things that are out of our control and we just do our best. So next, they have the right to comment on a plea agreement, and including the deferred disposition. There's a section of the statute on that we're going to look at. So that's like a right to participate, but they need to be informed that they have this right so they can exercise it. Next, if there's a proposed dismissal of the case, or when an indictment is going to be filed, or an information and complaint is going to be filed. So we're going to let them know that the case is starting. Then the time and place of trial, the time and place of sentencing. I know most folks are notifying for all court events, whether it's trial, sentencing, or a motion hearing. And then they also need to be informed of the right to participate at sentencing, which we'll talk more about that participation right. They also have a right to comment on the proposed early termination of probation, or if there's early termination of administrative release, which is pretty rare, or some conversion. So they need to know that they have a right to do that. They need to be notified, and these are new provisions that were just added this year. If probation has automatically terminated because DVIP has ended. Just today, I'm working on a one-pager that will help explain this in more detail. Oh, I want to go back. There's some really great comments from Joanna too about why we bother to do this. When everything is about the defendant's constitutional rights, having this little bit of rights that they own is a part of them having a feeling that it's about them and their loved one and not just about the defendant. And it's so true, Joanna, knowledge is power. So I digress. Again, why we bother to do this. The last piece that was added this year is that victims are entitled, regardless of crime type, they're entitled to know the final disposition of the charges against the defendant, including the amount of deductions to time served, so good time, that the defendant accumulated as of the date of sentencing. I've italicized this piece here where it sort of goes on and explains that the attorney for the state has to get this information from the jail in advance of the sentencing. This last provision around pre-trial good time is another piece that we're working on implementing. We'll have more information, because this is another piece, if you're like me, it's like a big, hold your breath, because that's a lot. And whether that's possible for small offices to do or for big offices to do, we're working on it. Okay. So there's a little bit of an anomaly in the statute where there's actually, in Title 15, there's a separate set of rights for victims of domestic and sexual violence and the crimes that cause a serious financial loss or a serious physical harm. And there's a lot of overlap between the notification rights that I just went over and the rights that appear in that statute. So the two pieces that I think are additional, and again, not rocket science and not things that I think people don't do in all of their cases, regardless of the crime type, are making sure to inform them that there's a victim advocate available for them and that they can access the victim's compensation fund. So if you're, and that does make sense that this would be a special addition. And then they have a right to make a statement or submit a written statement at the time of sentencing, also known as the victim impact statement. But we tell all victims about victim impact statements, I would think. And likewise, if you've made that call or sent the letter, they know that the victim advocate exists. Next, we're going to look at the right to participate. I think we cover this in some, when we talked about the right to information and the right to notification. And again, a lot of this goes without saying, but my question is, why does actually participating in the process matter to victims? This is, I think, for so many, the most important piece for them. And the thing that people have sort of the most emotions tied up in is having that opportunity to participate. Does anyone want to chime in? So, I think, again, if we're thinking about trauma recovery, just from a brain science perspective, having the right to be heard and tell your story and to have the court bear witness is, on like a brain science level, fundamental to moving on from what happened. So there's that. We also got a note in the chat. Brian says it can do a lot for the healing process. Exactly. So Brian's familiar with that concept too. Yeah, participating, and not everybody wants to participate. We don't need to force participation on everyone, but for those who do want to participate and find it meaningful, it can really be that keystone for healing and opportunity to feel seen.
To go off that for a second,
Yeah.
I feel like participation varies from person to person as well. Sometimes at a sentencing, people just want to be present. When I think participation, I think a lot of times people think that means they actually have to get up and say something. But I think just either being there or hearing the sentence, sometimes we'll contact them afterwards if they can't be present. Just knowing this chapter in the book is closed is huge. But I think participation a lot of time associates with, actually getting up and saying something.
Yeah, that's a really good point, Courtney, is that when we think about participation and when we're thinking about trauma-informed care, we're offering all these options and meeting people where they are. And sometimes exercising their right to participation, for them, what's most meaningful is sending you to be there, for example, and knowing that you're present and you telling them what happened, and that is what they need for closure, and that helps balance whatever sense they have of safety and accountability. Brian made a note here too that there's a loss of power control when you're victimized. Absolutely. And so being a part of the process can help with this, because it's an opportunity to take some power back. Potentially it's about confronting the defendant, or the defendant has denied what happened. They've told their version of the story maybe, and that's their chance to say, no, this is what happened to me. This is how it impacted me. So all of those things are really meaningful. And again, I highlight this because in the day-to-day, when we're working with hundreds of cases and hundreds of victims and all the sentencings and everything that happens, sometimes the idea of why we bother to do this can get lost in the shuffle. And so it's really important to go back and refocus every now and then and say, okay, for that one person, why does it matter? So first place where we have a right to participate is with plea agreements. Most of your cases are resolved by plea, right? So when the plea agreement is submitted to the court, the prosecutor is required to tell the court about all the attempts that were made to notify each victim that's part of that plea agreement, and any objections to the plea agreement that the victim has made, even if the victim isn't present in that case. So it's actually the prosecutor's affirmative obligation. This is a piece that you all as victim witness advocates, it doesn't fall on you. You would be feeding this information to the prosecutor, like, this is how we attempted to reach out to the victim. And this is why documenting all of those attempts to notify the victim are important for your own memory, but also to be able to fulfill this obligation. And likewise, the prosecutor is supposed to affirmatively say, like, so-and-so and so-and-so are on board with this agreement, but this other victim actually isn't on board. And then if the victim is present in the court when the plea is submitted, they have an opportunity then to address the court. There's also this provision that we already talked about in 2102 that dovetails here, where again, remember the victim is supposed to be informed of the plea agreement before it's submitted and informed of their right to comment. So that's how those two pieces fit together. Let's see, Joanna says that she has a much smaller caseload because she works on the homicide cases, but she often will submit the victim impact statement in writing to the judge prior if the victim can't get up and speak for whatever reason. So that's sort of going back to our overarching concept of participation. So that's actually a great segue into sentencing. So at sentencing, the victim has a right to either make a statement in the court. This is obvious. We do this all day. To submit the written statement directly to the court or through the prosecutor, knowing that it's going to become part of the record. There's no way around that. The other option that's in the statute is that an attorney for the victim can also make the statement on their behalf or submit the statement directly to the court. There's another part of the statute here that may be lesser known, so I wanted to flag this. The court has discretion to exclude anyone who's not an immediate family member from offering a victim impact statement. And the statute says that might be other family members or close friends or community members. So something to keep in mind, if there's a not immediate family member and it's really important for that person to be able to offer a victim impact statement, one of the things we can do to make sure or do our best to try to get that person an opportunity to be heard is to ask the defendant or defense counsel if they will stipulate to allow that person to make a victim impact statement. We could potentially make it part of the plea agreement that defense won't object to that person giving a victim impact statement. We can also file a motion in advance of sentencing and give the court all of the good reasons why the person shouldn't be excluded. Why this person is really the right person to talk about the impact of the crime. So I just wanted to flag that piece for you all so we can be thinking about it. There are more notification and participation provisions in the statute as well, but I didn't necessarily think that they require going into that much detail for today. So we've talked a little bit about if there's an early termination of probation or administrative release. I'm actually working on like a one-pager guidance that will help provide more detail on this if you're interested. A huge piece that is covered in the DOC Victim Services Basics training, which you can watch separately, is about the right to notification when a defendant is either released from incarceration or some other form of confinement. It could also be mental health confinement, or if they escape. What I will say about all of the release notifications is that victims have to opt in to those. They're not automatic. And so that's where you come in, making sure that victims know about their right to do this and helping to facilitate getting this information to DOC or to the county jail if we're talking about someone who's going to be committed to the county jail, so that those notifications happen. The other place where there's a right to notification and participation is in the somewhat rare, perhaps, circumstances where we have post-judgment motions to do DNA analysis. They do come up from time to time, and maybe the person is requesting a new trial based on DNA analysis. And the victim has a right to be notified that that proceeding is going on, and in some situations, a right to participate in that process. Next, we're going to look at compensation and restitution. And this is the last time I'll ask these like common sense questions. Why does compensation and restitution matter to victims? Why do we bother with the, let's say, sometimes headache of documenting compensation and restitution losses so that we can recover money for victims?
It's all about making the victim whole.
Yeah, right. We want to try to make the victim whole as much as possible. And this is a very tangible way. There aren't very many tangible ways in the criminal justice process to make victims whole. There are so many things that we can never replace and never fix. But if they're out money, the criminal justice system does an okay job. Depending on what we're talking about and who the defendant is, it can do an okay job of making the victim whole in this area. Any other thoughts about why we bother? I mean, for a lot of our victims, especially if we're talking about financial crimes and property crimes against vulnerable folks, the money that they lost, even if it doesn't seem like a lot to us, could really be a lot to them and make a huge difference. Victims' compensation, getting medical bills paid, getting co-pays paid for counseling, that sort of thing. These can make a huge difference. These financial supports can make a huge difference determining whether or not this victim is going to, first of all, access the things that they need, but it might make the difference in terms of helping them to have the money available to pay their rent so they can stay in their housing, so that they can make their car payment, so that they have a job and they can get to work. So restitution and compensation can make a huge, huge difference. And again, that's why we bother to have it in the system. Courtney says victims comp is fabulous and that Alma is always on top of things. Medical bills, changing locks, getting cameras, counseling for kids, and it's a huge help to help victims and their families heal. So yeah, we're not going to go into huge detail on compensation and restitution today. Big topics that could be covered in an hour and a half, all on their own. And for victims compensation, you can actually get you can go to Kelly McGillis's drop-in. So she's the director of the Victims Compensation Program, and she does a monthly drop-in just to do training on the right to compensation. But for today, one of the things that I shared with the prosecutors when they did their victim rights training, and I thought was really important to share with all of you, is to look at all of the hoops for victims compensation. So we have to show that it's a direct result of the crime, that we have eligible losses and expenses, that either the crime occurred in Maine or there are some exceptions to that are a little more complicated, that it was reported on time and filed on time. And, there are all of these hoops. I share this today not to discourage you from pursuing victims compensation with your victims, but to make sure that the way we communicate victims compensation is to say, you might be eligible and not to make promises that you cannot keep. to say, let's look at victims' compensation and see whether it's something you might be eligible for. Because when we have unmet promises, that erodes trust, it impedes recovery for victims. We don't want to do that. Instead, what we can do is call the helpful people of victims' compensation and have them support victims through this process so that we don't have those unmet expectations. They're always available to answer questions. The other thing I'll say too is that if it's a close case, all of the cases are decided by a board. There's a victims' compensation board, and victims can make an argument about why they're entitled to compensation. So that's another part of the process to also keep in mind. Although I do find that the program in general does everything that they can within the confines of the law to cover as many people and as many types of expenses as they can. Likewise, on the right to restitution, we could spend a whole hour and a half talking about how restitution works. What I'll say for today is, a couple things to remember. Restitution can go not just to the direct victim of the crime, but it can also repay the victim's compensation program once they've paid out for a victim. One of the things we haven't talked about is how important restitution is when we're thinking about accountability for the defendant, right? If you think about when you were a kid and you hit your baseball through your neighbor's window, what's the first thing that your parent has you do is go over, make amends, fix it. Maybe you pay your allowance to fix that window. It's such a huge part of our culture that we make amends and we fix what we break. And so restitution has that benefit as well. And that's why one of the many reasons why we bother to make sure that restitution is used to repay victims' compensation when they pay out on a victim's behalf. Another thing to note that's in the statute, the court is required to ask about restitution. It's the defendant, not the state, that bears the burden of proving the defendant's inability to pay. Another misconception is that, well, if the defendant's going to jail, they're never going to be able to pay restitution, so we shouldn't bother. But important to know that if the defendant is committed to a DOC facility, DOC can and does collect from their facility residents, and they also collect from their probation clients. Another thing that I've been working on, and some of you may even be familiar with this, is that DA offices can pursue state tax refunds to satisfy unpaid restitution debts. And there's a process for that if that's something your office wants to work on. We also have some friendly tips from our restitution group, which is to ask for help. And that's not just within your office, but I actually have a restitution clerk email list if you have a question that you want to put out statewide to get an answer. Some restitution orders are put in as up to awards. So up to awards can work really well for victims' comp cases. The cap on victims' compensation is $15,000. You could potentially, if at the time of sentencing, it's still up in the air how much compensation is going to be paid out on behalf of the victim, you could say up to $15,000. That's the cap. It's easy to document in order to make sure that as the defendant pays in, that the actual losses are being repaid. With that said, up to awards aren't as helpful if it's going to be impossible to document the loss. So we want to try to avoid those up to awards in property cases. Also, don't just rely on the police report for the dollar amount. Often, the law enforcement officers who go to the scene, they're not necessarily focused on getting an accurate number. They don't have the ability to get an accurate number. No one's pulling out their documentation right there. And so pulling a number out of the police report is not going to get us a good restitution order. You can, if you're having trouble, you can actually request that the court set out a separate restitution hearing to allow more time to gather documentation if we have a complex case. The restitution clerks also say to make sure you do the math on the payment plan. So a payment plan of 50 cents a month is going to take a long time if we're talking about $500. and it's probably not worth it. If you're in a situation, or if your prosecutor's in a situation where they're thinking about stipulating to a payment plan and the math just doesn't make sense, this might be a case where we want to just set this for a contested hearing, or we want to back off from the idea of a payment plan altogether, and we're better off with an order that doesn't have any payment plan. Also, when we're thinking about ability to pay, with defendants, we want to be thinking about whether they have possible retirement, pensions, or other future income that could come in, and not just whether they have a job right now. So these are our tips from our restitution clerks as we're thinking about helping victims get restitution orders that will get them repaid. And that is what I have for you today on the victim rights basics under Maine law. Do we have any questions or just general comments from the crowd that would be helpful? Thanks, Joanna. Thanks for being here. Anything else from folks? Questions or comments?
I think it's always good to just kind of get a reminder when you've been doing this for a while, or even if you're new, especially if you're new, but to kind of be like a refresher on all the stuff we know that's in there, but oh yeah.
Yeah, no, it's good. And I learn something every time I go through it myself. And the other thing I'll say too, if you don't have it, I will make sure you get a copy. There's the Victim Rights Law Guide, which has all of the statutes all in one place. I'm going to make sure that gets updated annually, but it is current with all of the new state law changes. So that's one place that you can consult if you have questions. I'm also working on some practice guides on tricky areas. So I think in another couple of weeks, there should be a best practice guide on privacy and confidentiality that not just lays out what the law is, but some tips on how to make it work. And then I'm working on another one, like I said, on the early termination of probation, especially when we have cases that involve domestic violence intervention programming. So if you have other thoughts on like specific trainings, areas where you tend to have a lot of questions with victim rights law, and a practice guide would be helpful, don't hesitate to email me. Now I'm going to turn off the recording.